Good afternoon. What's your name, sir?
Cornell McCreary, capital rest lowercase, not the all caps, sir, which legally denotes a corporation.
Alright guys, buckle up because today's courtroom story gets wild fast. What starts as a routine hearing quickly spirals into one of the most chaotic sovereign citizen performances you'll ever see. The moment the judge asks the defendant a simple question, his name, the man immediately launches into one of those classic sovereign citizen arguments about capital letters and corporations. According to him, writing his name in all caps somehow transforms him into a legal corporation instead of a person. The judge, clearly experienced with this nonsense, stays calm but firm. Meanwhile, the tension in the courtroom starts rising fast. This isn't just another misunderstanding of the law, it's the beginning of a full-blown legal meltdown. And trust me, as this hearing continues, the defendant will throw every buzzword, statute, and conspiracy-style argument he can think of at the court.
Thank you, sir. I'm not the typist around here, sir, so we're going to go with it the way it's spelled.
May I please address the court, sir?
Sir, I'm sure your counsel would suggest that you not do that, but you have a right to do that if you want to over your counsel's very solid legal advice.
Judge, if I may briefly, for the record, PA 365. Mr. McCreary did not want us to represent him. We tried to represent him. We would like to help him and represent him.
I'd like to represent myself, sir. Under Michigan Constitution, Section 3, Article 13, represent myself, Judge.
Now here's where things start getting serious. The judge asks the defendant whether he wants legal representation, a very basic question in any criminal proceeding. But instead of accepting professional help, the man proudly declares that he will represent himself. Now listen closely, because this is where many sovereign citizen cases start collapsing. Representing yourself in court might sound empowering, but without legal training it can quickly become a disaster. The judge carefully explains his constitutional rights, reminding him that he has the right to an attorney and even a court-appointed lawyer if he can't afford one. Despite that clear warning, the defendant insists on moving forward alone. The judge notes it for the record, making sure the man understands the consequences. What happens next proves exactly why experienced judges strongly recommend having legal counsel.
All right, sir. It appears that you have a desire to represent yourself. Let me just ask you a few questions. You're aware that either right now or at any point while this case is pending, you can have the assistance of counsel should you so desire. Are you aware of that?
I am aware, sir.
All right, and it's your decision at this time to proceed without counsel, is that correct?
That's correct, sir. Appropriate persona under Michigan Constitution 1963, Article 13, sir.
Alright, now the charges finally come into focus, and they're not minor. The prosecutor explains that the incident occurred while the defendant was already in custody. During prisoner transport, as officers were escorting him toward a holding cell, the defendant allegedly leaned toward a police officer and spit directly on him. That action alone turns this situation into a criminal assault case. The prosecutor describes the event calmly, but the seriousness of the allegation is obvious. Assaulting an officer, even in a seemingly small way, is taken extremely seriously by the courts. Because of that, the prosecution requests a $1,000 cash bond. At this point the judge gives the defendant a chance to respond, and this is where the courtroom begins filling with complicated legal jargon, strange arguments, and claims that the court supposedly lacks jurisdiction.
All right.
I am very
hold on, sir. Hold on. While you do have a right to represent yourself, you do not have the right to talk over me, sir. So let me say a few more things. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, which we've just discussed. And if you cannot afford an attorney, the court will provide one for you. In fact, we have several attorneys here today who are very capable. Of course, you can turn down that constitutional right, and it appears that that's what you're doing. Let's see. You're charged here with one count of misdemeanor assault or assault and battery. Maximum penalty is 90 days and or $500. And of course, going to enter a not guilty plea on your behalf, sir. We're going to hear a few words from the prosecutor, and then it'll be your opportunity to speak if you so desire. Mr. Prosecutor.
Thanks, Your Honor. Again, Steve Vincent on behalf of the people. The complaining witness, Your Honor, in this case is a police officer. Apparently, during prisoner transport, the defendant walked past the police officer who was in and around the area while the defendant was being escorted to the holding cell, and defendant took it upon himself to lean towards the police officer and spit on him. As a result of the defendant's actions, the people will be asking for $1,000 cash bond.
Mr. McCreary, anything you want to say as to bond, sir? I do caution you not to discuss the alleged facts of the case, but it's up to you.
Well, I first would like to challenge personal jurisdiction, subject matter jurisdiction, territorial jurisdiction. This is a structural error, Your Honor. Under MCL 767.24, Judge, this statute of limitations has told this is a structural error. This is prosecutorial misconduct under Michigan Rules of Professional Conduct 3.8, sir.
Here's where the sovereign citizen playbook comes out in full force. The defendant suddenly begins rattling off legal phrases about personal jurisdiction, subject matter jurisdiction, and territorial jurisdiction. He claims the court has no authority over him and begins citing statutes like Michigan Law MCL 767.24, insisting that the statute of limitations has already expired. But the way he presents these arguments makes it obvious that he doesn't fully understand the laws he's quoting. Judges hear this kind of tactic constantly. Sovereign citizens often cherry-pick legal phrases and assume they magically invalidate the entire case. In reality, courts rely on precise legal interpretation, not random citations thrown around like buzzwords. The judge listens patiently but firmly keeps control of the courtroom, reminding the defendant that talking over the court will not be tolerated.
I was in the Department of Corrections from, I believe it was I know it was 2002. I was released in August of 16. Paperwork, everything. I've been filing complaints against the prosecutor's office. Kim Worthy, where a judge heard it on appeal, Kirsten Frank Kelly. It's been crimes against me by the prosecutor's office. And I would like to move for a change of venue where it's clearly documented, Your Honor. And the statute of limitations has told, I don't know nothing about this case. Why wasn't I processed or liens checked before I was released from prison? I've been home 6.5 years, Your Honor. This is a crime in violation of misconduct in office, MCL 750.505. Also 18 USC 241, 242 per the federal statute. Embler versus Patchman, the prosecutor does not have absolute immunity. Judge, and I exercise the common law. I demand that this case be heard under the common law, Judge. I've been home 6.5 years. No threat to anyone. I've been working. I have had 5 children since I've been home. I'm a grandfather. I have 2 grandchildren, 1 on the way. And I've been trying my best, and people have been calling, making false complaints on me, and it's well documented. I've tried to press charges, and the prosecutor won't do anything. This is selective prosecution, vindictive prosecution as well. It's all documented, sir. And I ask that this case, I would like again to challenge personal subject matter and territorial jurisdiction. Under MCL 767.24, the statute of limitations have told. They have been notified of any pending warrants or anything else while I was incarcerated before I was released. I've been home 6.5 years, haven't been a threat to the community, haven't been a threat to anyone. People have made false complaints on me, and I filed police reports with the Department of Justice, the FBI, the state police, and DPD, the 10th precinct. And it's documented, and they don't want to let me press charges. This is selective prosecution, Judge.
But the defendant isn't finished yet. He starts telling the court about his past, claiming that the prosecutor's office has been targeting him for years. According to him, multiple agencies, including local police, state authorities, and even federal investigators, have ignored his complaints. He argues that the entire prosecution is selective and vindictive, insisting that people have been filing false reports against him for years. He even says he has tried to press charges against others, but prosecutors refuse to pursue those cases. To him, this proves corruption and misconduct. But to the judge, these statements have little relevance to the charge currently being discussed. Courts operate on evidence tied to specific cases, not broad personal grievances. As the defendant continues speaking, the courtroom tension rises even higher.
So I
Thank you,
asked
sir,
for
for your.
dismissal of this motion.
All right,
And I
motion to
object
dismiss motion to dismiss is denied. I don't have the authority to dismiss the case. The issues you raised, sir, are more properly brought before the judge who's going to hear this case, which will be Judge Bryant, and you can raise those issues at your next hearing. What I will do at this time is set bond as follows. Counsel, what was your request?
People were requesting $1,000 cash as a result of the actions in this case.
Okay.
I object. He just said
Sir.
he's being vindictive, Your Honor. I
Sir,
object.
do you have any financial means with which to post a bond of any type today?
I have $300 on one credit card and I have $40 on another card, sir. And I'll be more than happy to give you whatever I have. I've been trying, Judge. I have tenants. I have my home. I have kids I need to get home. I haven't been a threat to the community. People have been lying on me, Judge. And it's well documented, man. And I put myself on personal court. And again, I object under UCC 1-308. I reserve my rights not to be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, voluntarily, and intentionally.
Now the judge finally steps in and delivers the decision regarding the defendant's request to dismiss the case. The ruling is simple and direct: motion denied. The judge explains that he does not have the authority to dismiss the charges at this stage. Instead, those arguments must be raised before the judge assigned to the upcoming trial. It's a procedural decision, not a judgment on the merits of the claims. But the defendant clearly isn't satisfied. Even after the ruling, he keeps citing additional legal codes, court cases, and constitutional arguments. One of the most common sovereign citizen tactics appears again when he references the UCC, the Uniform Commercial Code, claiming he reserves his rights under it. The judge quickly shuts that down, explaining that criminal cases are not commercial contracts.
Furthermore, I do not accept the liability of revealed contracts. Also, I would like to cite a case to the court, Foy versus City of Berea, 58 Federal Third.
Sir, I don't mean to cut you off, but I do not have the authority to dismiss as you requested. So it doesn't do you any good to give me all the citations. You can raise all of that with Judge Bryant on your next court date, okay? So court's going to set bond at $1,000, 10%. That'll be $100 to you, sir, which you've indicated is an affordable bond.
I got my card.
Yeah.
Yes, sir.
If for whatever reason you don't post, you'll have an affordable bond hearing tomorrow morning. But if you do post, you don't have to worry about tomorrow morning. Your next court date will be in front of Judge Bryant on June the 7th here in 36th District Court for a pretrial, and I'm sure that she will entertain your motions at that time.
At this point, the conversation shifts to bond. The judge asks whether the defendant has any financial ability to post bail. His answer is surprisingly honest. He admits he has only small amounts available on 2 credit cards. Despite the earlier legal chaos, the judge still attempts to keep the process fair and structured. The bond is set at $1,000 with 10% required, meaning the defendant would need to pay about $100 to be released. The judge also schedules the next hearing with another judge who will handle the pretrial proceedings. Even then, the defendant tries one last round of arguments, claiming prosecutors are violating constitutional provisions and accusing them of treason against the Constitution. The judge calmly ends the discussion and moves the case forward.
Actual question,
Go ahead.
Your Honor.
Yes, sir. Go right ahead.
I would like to state this, that the prosecutor is under oath under Article 6, Section 3. Right now, they're violating their oath. There is a case called U.S. versus Will, where they have jurisdiction to act and they don't act, and if they don't have jurisdiction to act, it's treason against the U.S. Constitution, sir, under the common law. And I ask that you send this matter to the Michigan Attorney Grievance Commission, Judge, because of misconduct on Kim Worthy and her subordinates.
Okay, sir. Again, that's something you can raise with Judge Bryant when you see her in June. Also, with regard to the bond redetermination date, that will be Wednesday, should you not post. If you post, you don't have to worry about it. If you don't post, that will be bond redetermination on Wednesday morning in front of Judge McConico here in 36th District Court. Thank you, sir. You
I
can
use
step
my,
aside.
I use my credit card.
Alright guys, here's the twist that makes this story even more intense. The narrator reveals that this hearing is only the beginning of a much bigger case. The defendant isn't just dealing with the current assault allegation. According to the upcoming proceedings, he could also face extremely serious charges connected to events from years earlier, including assault with intent to commit murder and firearm-related felonies. And remember the statute of limitations argument he was so confident about earlier? That's where things might backfire. Under Michigan law, the state actually has 10 years to bring certain violent felony charges. If that applies here, his entire legal argument could collapse. So this hearing is just part one of a much larger legal battle, and things are only going to get more explosive from here.
I use my credit card.
And we're on the record as the people of the state of Michigan versus Carnell Michael McCurry in all lowercase letters. 2305648. Mr. McCurry is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felony assault. Count 6, 7, 8, and 9, weapons, felony firearm. Also count 10, weapons, felony firearm. Set for a motion here today. Appearances.
Edwin Sawaki, P 5482A, appearing on behalf of the people.
Mr. McCurry, say your name, please.
Carnell Michael McCurry, ill, all lowercase, acting appropriate, persona under Michigan Constitution 1963, Article 1, Section 13.